Welcome this afternoon to today's special called meeting to hold an appeal with the Cobb County Historic Preservation Commission. I will turn things over to Bill Roebling, our county attorney, to walk through today's events.
Thank you, Chairwoman. If I may inquire, since we're doing a presentation, typically when we're having a hearing, we allow the other applicant to sit at that other front row, if we could do that. Mr. Schwartz, if you can come up to this front seat up here. I'm sorry. This one's a little bit different than our usual meetings, so it's actual presentation.
Okay.
Okay, Commissioners, I just want to go through a little bit regarding what we're here for today and what's happening. This is actually an appeal to the board, and I will be serving as your hearing officer today. The appeal is ruled has been filed properly. The clerk has properly noticed this hearing today at this point in time. The hearing is taking place within the 90 days of filing the appeal based upon consent of the parties, based upon some health issues that occurred. Each party has a right to present a position paper, which they have done and has been provided to each member of the board regarding that. The particular procedures for the hearing today also include that any aggrieved party that is not actually the property owner, which is in this instance, can also, through its representative, fully participate in that hearing or elect to simply make a 10-minute presentation to the reviewing body. In this instance, the aggrieved party who's not the property owner is Mr. Rowland. Mr. Rowland, R-O-W-L-A-N-D, not spelled the same way as mine. He is here, and he is represented by Mr. Moore. So I just want to go through a little bit regarding the procedures for the hearing. Any pre-hearing motions are to be heard and ruled upon, which have not occurred. There are none at this point in time. When the hearing is to proceed, each party is allowed to have a 3-minute opening statement. Then each party has 20 minutes in order for them to be able to present their case. And I'll ask some diligence from the parties. I'm going to have to keep track of the time. It's a cumulative time. And whenever somebody's, if there's witnesses that are presented or questions that are from the board, that time is not to be counted against your 20 minutes. And so I'll have to do the calculations over here as we're moving through with that. After each side has presented their case, they then have 3 minutes to present to the board a summation. Then the members of the BOC then may question each witness or the presenter. The appellant, when he goes, may reserve time for any rebuttal from his initial time that he has on the side that he presents. The rules of evidence as set forth in the Georgia Civil Procedure Act shall not apply to the hearing described in this section. Upon objection of either party for anything that is submitted, the hearing officer shall rule on the admissibility and evidence, and evidence shall be admitted if necessary to serve the substantial justice. That is the standard. The legal standard by which this board is to consider this matter is abuse of discretion. In this proceeding, the BOC is actually acting as a judge in somewhat of an appeals, a quasi-judicial action. You're not in your legislative role. And the legal standard to be applied is abuse of discretion. If the hearing has not been concluded by 5:30, which I assume that we are hoping that it will be by then, that it may be continued to another date certain. At the conclusion of the hearing, the reviewing body may issue a ruling or may take the case under advisement. In the event the case is taken under advisement, the chair will announce to the board the intent to render a ruling within a specific number of days and then set it down for a specific time at that point in time. If it comes to that, we have some suggestions. The reviewing body may discuss at the next week's work session. However, the final determination must be announced at a public meeting, which has been properly posted and noticed. If the case is taken under advisement, council shall not discuss the case particulars with commissioners or members during the advisement period. No emails or public statements on this issue that occurred after the date of the hearing should be taken into consideration by the commissioners. Following the date of the decision, following the decision of the reviewing body, a written decision shall be issued. With that, unless there's any questions from the board, we can start with the appellate's first 3 minutes of the presentation.
Yes, I do have a question for you regarding procedure.
Yes, ma'am.
Can you clarify to the board what disposition actions we can take when this concludes?
Yes, I can.
Thank you.
Pursuant to the code, which is under 6691, and I'll just read the code section to you so that we're very specific. Excuse me, 6696. Any person adversely affected by any determination made by the commission, and they're talking about the Historic Commission, relative to the issuance or denial of a certificate of appropriateness may then appeal that determination to the Board of Commissioners. Okay. The appeal must be applied for within 15 days, which it was here. The county then may approve, modify, or reject the determination made by the commissioners if the Board of Commissioners finds that the commission, as the Historic Commission, abused its discretion in reaching its decision. And then appeals from this decision can then be taken to Superior Court.
Thank you. Do any commissioners have any additional questions? I know some of us have been on a similar appeal before, but some of us may not have. So if you have any questions regarding process, please feel free to ask, because this decision is going to be determined by those of us here on the dais today.
Okay.
Then Bill, please.
With that, Mr. Schwartz. Now you can approach the podium. This will be for your first 3 minutes of your opening. And I'll instruct counsel, there is a timer that's there on the podium, and I'll start it with your first word.
Okay. Thank you, Mr. Rowland, and good afternoon, commissioners. My name is John Schwartz. I represent the appellants who live in the surrounding area, including Chris Ledoux and Genevieve, who live next door in the Rock House. This has been in front of the commission, in front of the Historic Preservation Commission several times now. And the prior application before this one, the certificate of appropriateness was approved. The Board of Commissioners affirmed that. We appealed that to the Superior Court, and we challenged the several issues, but one of them was that the Historic Preservation Commission failed to look at the impact to the intact historic area, which we refer to as the immediate neighborhood. So that comes from Georgia Historic Preservation Act, and also what used to be in the Cobb County Code, and it says when you're reviewing a certificate of appropriateness, the commission has to make its determination based on looking at the relationship of the proposed structure's architectural features and styles and comparing that to other structures within the immediate neighborhood. In the prior case and in this case, the Historic Preservation Commission did not limit its review to comparison between the proposed structure and other structures within the immediate neighborhood. Instead, they said that there was no way to distinguish, and they looked at it based on impacts to the entire district. The Superior Court reversed that decision and said not only was it error to fail to distinguish between the immediate neighborhood and the rest of the district, but that the Historic Preservation Commission erred as a matter of law in looking at houses and comparing the structure, the architectural features and styles to other houses outside of the immediate neighborhood, that they had to limit the comparison to within the immediate neighborhood. After that decision, the board revised the county code but the Georgia Historic Preservation Act still applies. And the Superior Court based its decision on both the prior code language and the Georgia Historic Preservation Act. And under the Georgia Historic Preservation Act, that the board, the Historic Preservation Commission's authority specifies that they have the authority to issue certificates of appropriateness in accordance with the Historic Preservation Act. And I'll explain this more when I come back here, but the Georgia Constitution prohibits the county from passing an ordinance that is in conflict with a general law. And that's what happened here. So I can explain that further. But the historic...
Mr. Schwartz, I'm sorry, your
Thank
time's
you.
up.
Okay.
Mr. Johnson.
Good afternoon, Commissioners. My name is Brian Johnson on behalf of the Cobb County Historic Preservation Commission. You're here today to consider whether the Commission abused its discretion when it approved a certificate of appropriateness for Mr. Roland Davidson to construct a new single-family home in the Concord Covered Bridge Historic District. The Commission considered his application, applying the standards set forth in the Cobb County Code. And this is not the first time, as we've heard, this application has been submitted and received and approved by the Historic Preservation Commission. The Commission acted within its discretion, and the COA was properly approved based upon the application and the facts presented at the September 27, 2021 hearing. The appeal should be denied at this point, but the Commission decision stands because, first, the Commission did consider the architectural style of existing dwellings in the intact historic area. Second, certificates of appropriateness are considered by the Commission utilizing United States Secretary of Interior standards for rehabilitation and guidelines for rehabilitating historic buildings for new construction on vacant lots pursuant to the Cobb County Code. Third, the Commission did not err by relying upon staff analysis, which compared the proposed homes to a variety of dwellings, specifically to the Rock House. And fourth, the COA submittal criteria reviewed by the Commission was correct and complete. Following Cobb County Code, the Commission reviewed evidence showing the new construction will be compatible in design and scale and materials and setback and landscaping as the other homes in the district and within the intact historic area. The standard of review here is to apply is whether the Commission abused its discretion when it approved this COA, this Certificate of Appropriateness. It's not necessarily whether you agree with the decision or would have made a different decision, but whether there is evidence before that Commission to support that decision. This decision was proper and supported by evidence, and I ask you, and will ask you later, to uphold that decision. Thank you.
Mr. Moore.
Good afternoon, Madam Chair and Commissioners. I'm here, and my name is Kevin Moore, and I'm here and very pleased to represent Mr. Roland Davidson, the property owner that's the subject of this appeal, who was issued, again, a certificate of appropriateness for his proposed single-family home to be his residence for him and his wife for the property he's owned for many years, located at 45 Concord Road. It's a 1.5 acre property. He intends to build his one single-family home on this property and has been trying to do so since 2017 and has been thwarted through these various appeal processes. Mr. Davidson, if you're not familiar with him, Mr. Davidson is a president and co-founder of the architectural firm of Lyman, Davidson, and Dooley. He is a professional architect. They founded that firm in 1988 right here in Cobb County and still reside here in Cobb County. They are a preeminent and respected architectural firm, the recipient of numerous awards. They have an impeccable reputation for the quality of their work and their professionalism. What we're going to be asking this board to do is to uphold, again, the Historic Preservation Commission's issuance of the Certificate of Appropriateness so that Mr. Davidson can finally build his home. We will present to you today several legal arguments that we believe will be serious and consequential should the board decide to reject the Historic Preservation Commission decision and for these appeals to continue. We will also present to you a human element, and that is in the form of Mr. Davidson, so that you can hear directly from him what he has gone through and his design and his architecture and what he brought to the table in terms of providing for his application for certificate of appropriateness and how just appropriate it was. At the end of the day, we will ask you to uphold the Historic Preservation Commission's decision, and we think you will wholeheartedly agree to do so. Thank you.
Mr. Schwartz?
Excuse me, Bill, before he comes up, I just have a clarifying question. Excuse me again, I'm just trying to make it crystal clear what we are looking for in this hearing. The legal question is clear that we're looking to see if there was abuse by the commission in making its determination for the certificate of appropriateness.
Correct. The abuse of discretion in that, in them making that decision.
And then I was trying to pull out were there particular elements or criteria that we're looking for to see if it was or was not met?
Well, there are, and I believe the appellate will set out why he believes there was that abuse of discretion at this point in time on what those elements were.
Okay, if you can help make that crystal clear, those criteria that we're looking for. Yeah. Okay, thank you.
And just to clarify specifically what you're asking, are you asking what is the legal standard for abuse of discretion mean?
Thank you.
Not specifically on this case, but just in general?
Yes, thank you.
Yes, okay.
Okay. I misinterpreted. I thought what you specifically were looking for.
No, I know we're looking for evidence of that.
Okay.
So we're going to go through the
Right.
facts and the history,
Right.
but I just want to,
I did anticipate you asking for what that particular standard
Okay.
is, so
Yes,
I'm
thank you.
sorry I misinterpreted what your
No
question
problem.
was. The standard for reviewing the adjudicators, in this instance, the Historic Commission's decision, is as to whether the body failed to exercise sound, reasonable, and legal decision-making.
I'm going to write this down.
Okay?
And repeat that again, take your time.
Whether the decision-maker failed to exercise sound, reasonable, and legal decision-making.
Sound, reasonable, and legal decision-making.
Yes.
That's it.
That's a
Okay.
Black's Law Dictionary of abuse of discretion.
Thank you, appreciate it. Thank you.
Thank you. And just to...
I'm sorry, Ms. Schwartz, did you want me to reserve any time for you?
Yeah, I would like, let's see, so 20 minutes, say 5 minutes.
Okay, I'm going to reduce this time down to the 15, so
Okay,
you'll see what you
thank
have. Okay.
And to address the standard, the legal standard, we're not asking this board to make design decisions. We did file an affidavit by Jerry Weitz, who's our historic preservation expert, and it addresses the design issues to explain some, really, I think, so there's some context here on, because I know from Mr. Davidson's response filed yesterday that they're trying to explain how this fits in, how he's worked to make it compatible, how he's tried to change the application to make the neighbors happy. If you look at Dr. Weitz's affidavit after the first 3 pages, there's markups that we had previously submitted, and I do have a copy. I don't know if you received those because we just, Dr. Weitz just.
Mr. Schwartz, if you want to, you could use CP. They will help you, and they'll put it up on the board where they can see
That
it.
won't take me too much time, but if I can just pass these
Okay.
out to the commissioners and then.
You can hand them to the clerk, and then she'll make sure that they receive.
Thank you. So I'm going to go through this a little bit fast because I do not have a lot of time, but Dr. Weitz on his, previously on a prior application submitted markups. And I'll just leave that one so you can see it, but it's.
And they all have
starting at-
screens in front of them, too,
Okay.
so they're able to see
But
that as well.
if you compare this with the plans that were submitted, almost every single concern that was raised is still there. And I think most significant for the actual review by the Historic Preservation Commission is the rear elevation, which is on the, let's see.
Mr. Schwartz, if you'll use the handheld microphone when you're over there, and then you can keep on
I'm
talking.
not even going to go over there because this is going
Okay.
to take me too much time. But the rear elevation was really not considered because they kind of, it seems like from the staff report that they were assuming that what was visible was really from the front side, and the rear elevation still has broken up irregular gables and roof line that Dr. White says is not appropriate, but really there's almost nothing has been changed. This house has been pushed back a little bit, and a couple of their minor details, but there really doesn't seem to have been much effort to really come to terms with the neighborhood here. But I'd like to get back to the legal issue, because it doesn't really matter here whether this design could or could not ultimately pass the Historic Preservation Commission and get a certificate of appropriateness, because it's the procedure that's a problem here. And the Superior Court remanded this case with instructions on what the Historic Preservation Commission was required to do upon review. And there's three primary issues that the Historic Preservation Commission ignored. Two of them is because they thought that they no longer had to follow the language requiring comparison to the immediate neighborhood, because the code was revised, but it's still in the Georgia Historic Preservation Act. It still applies, and this was in our position paper, but the uniformity clause under the Georgia Constitution, it requires local ordinances to be, when there's a general law that's uniform throughout the state, the local ordinance cannot conflict there. And here, it's very clear that the Historic Preservation Act specifically says in it that it's intended for a uniform procedure throughout the state. And it says that when reviewing a certificate of appropriateness, they have to look at the relationship of the proposed structure's architectural style and features to others in the immediate neighborhood. The Superior Court specified that the immediate neighborhood here is the intact historic area, and said that the Historic Preservation Commission erred by looking at homes that were outside of that area. That error was repeated again. The other error that was repeated was the Superior Court said that the Historic Preservation Commission erred by relying on non-historic intrusive homes, which are homes that have no contributing architectural style. So even if a home is less than 50 years, it can still just be considered non-historic, where it just has architectural style, but it's not historic. But intrusions actually have no historic style by definition, and here they expressed or relied on those. The Superior Court found that that was error the first time it was repeated here. The other error that the Superior Court found was on the submittal criteria. The Superior Court said that the submittal criteria must be followed. There's no discretion there. Either that if the submittal criteria is not included with the application, it cannot be reviewed. Here, the application did not have the correct setback from Nickajack Creek. And we raised that issue in front of the Historic Preservation Commission, and they said, well, that can be addressed later. Now the applicant is essentially saying, well, that's not the type of setback that has to be included. But the Nickajack Creek, when the district was created, the Historic Preservation Commission noted that that is a contributing factor towards the historic significance of this district. And so those three legal errors are really just, it doesn't matter how good the design is or not good, but I would like to tender some exhibits into the record. One is a certified copy of Chapter 66 of the County Code, which is a historic preservation ordinance. One is the affidavit I just handed you from Dr. White's. And then another is a deed from Jim McCutcheon to Christopher Ledoux. This is in response to an issue that was raised yesterday in the applicant's position paper, claiming that the Superior Court order is not binding because it's different parties, but and also trying to claim that law of the case is the legal doctrine that would make it binding, but that's not the issue. You can discuss this with counsel because it's probably not going to be an issue you're necessarily familiar with. But what this gets at is what's called res judicata or collateral estoppel. And this is an issue that has already been determined with these very facts. Now, the applicant is trying to say, well, the application has changed, but there's nothing material to our appeal that has changed in the application. Otherwise, anytime an applicant loses in Superior Court, they could just change one irrelevant issue and try for a do-over, and that's just not how it works. With respect to the parties not being the same, Georgia courts say that if it has to do with the actual property, then if the property is sold, the person who buys it is in privity, and the collateral estoppel or res judicata still applies. And I'll get back with you on the case on that. What the applicant's position paper did not discuss, because there really is no defense to it, is our argument on the uniformity clause. There's just no way around the fact that the Georgia Historic Preservation Act must apply here. The Superior Court based its decision on both the Historic Preservation Act and the county code. At that time, it wasn't so important as to whether it was one or the other, because they were really in conformance with each other. But now that the county code is different, it's the Superior Court's decision is still binding. And even in the Historic Preservation Commission's bylaws, it specifies that they have the authority to issue certificates of appropriateness in conformance with the Historic Preservation Act. It also refers to the county code, but it's both. And to the extent that there's any conflict between the two, under the Supremacy Clause and under the Uniformity Clause, the Georgia law must apply. Now, we raised an issue about the Secretary of Interior standards and guidelines not applying to new construction. I don't want to dwell on that too much. I don't think it's not, some local governments do apply it, but the standards themselves are not intended that way. They specifically say that it's for preserving the historic integrity of existing structures. They were initially developed for tax purposes on rehabilitation of historic structures. But we raise a point that where it's new construction in a district with no design guidelines, that there is no criteria to apply if they're not applying the Historic Preservation Act, because all that's left would be the design guidelines or the standards, which we say don't apply. The applicant in the position paper made the point of, well, if there's no standard to apply, then the whole ordinance is vague and would be unconstitutional. But what we're saying, though, is the standard that applies is the standard that's in the Historic Preservation Act. So it's not it's not vague unless if it's.
Mr. Shorts, could you just hold on one moment?
Yeah, I'm sorry.
For a
Sure.
brief recess. I stopped your time, Mr. Schwartz. So.
Sorry about that interruption. You
Oh, that's
may
okay.
continue.
So the case on collateral estoppel and privity between property owners is Say v. Roberts, 275, Georgia Appeals 295, and that's a 2005 case. And the code section on the powers of the Historic Preservation Commission to review certificates of appropriateness in accordance with OCGA 44-10-28, that's at 44-10-25. The commission just doesn't have the authority to issue it without conformance with that. This one does not, because they didn't consider the immediate neighborhood. They looked at a structure in the immediate neighborhood, or a couple structures, but they didn't limit their review to those structures, as the Superior Court said is required. And even if the code hadn't been, even if the Georgia Historic Preservation Act didn't apply, it would be error to rely on these intrusions. That's defined at the county code 66-57, and that's expressly prohibited by the Superior Court order, yet the Historic Preservation Commission again relied on that. And when you look at the motion that's in the minutes to approve the certificate of appropriateness, and when you look at the certificate of appropriateness itself, it specifically says, and this was in response to my request that they review it under the state act, that it specifically says it's being reviewed and approved in accordance with the county code and the Secretary of Standards. The commission expressly refused to apply the state law, but even if they said that they were applying it, they erred in their application by looking at structures outside of the historic, outside of the intact historic area. And the intact historic area, that area is still eligible for listing on the National Register. There's been some, in the applicant's position paper, raised the point that there's no significance to being designated as a district, and because it doesn't limit what you can do on private property, and also trying to say that the State Historic Preservation Division already determined that that the district is no longer eligible. The reason the district is no longer eligible is because of the intrusions that have been approved since the district was created. Now they're trying to use the fact that the Historic Preservation Commission has not done really like a good job over the past couple of decades in allowing these homes, and then trying to rely on those homes to allow more to come in under that. But what's happened to the rest of the district, while it shouldn't have happened, but it's really not so relevant to what should happen in the intact historic area under the Superior Court standard, which is, and the standard of the Georgia Historic Preservation Act. Now, Jerry White's in his affidavit says that the house as designed would impair the intact historic area's eligibility for listing on the National Register. And the National Register does provide benefits, including if there was ever any like federal funding for like repairs on the east-west connector, then there would be a Section 106 process to look at how to minimize impacts to the intact historic area if it was registered as a district, but not otherwise. Let's see, so also in the applicant's position paper, they raised the point about the bylaws being amended, but the bylaws were amended at the same meeting, but after the vote on the certificate of appropriateness, so they cannot rely on like the changed bylaws for reviewing this certificate of appropriateness. And the bylaws specifically say that they can approve applications as set forth in the Georgia Historic Preservation Act. Last point, I would just like to tender in the minutes. I don't think that's in the record yet. Well, it's in the
We'll
position
take up that at the
paper.
end.
Okay.
Sure.
Okay.
And your time's run, Mr. Schwartz, but
reserve
you do
my-
have 5 minutes for.
Thank you. I'll reserve the rest of my time.
Thank you. Bill,
Mr. Johnson?
excuse me, Bill, when is it appropriate for the board to ask questions to?
You can ask questions, if you have any questions for Mr. Schwartz now.
Yes,
You-
why
Yes,
don't-
okay,
yes.
that'd be fine.
Thank
Before,
you. Appreciate
I didn't know if you wanted to hear everybody before you ask questions, or you can call them back up as you want to.
Okay.
But if there's some clarifying questions you want from the applicant at this point in time, that'd be appropriate. And this does not count against his time
Okay.
at that point in time.
Thank you. Okay. Do commissioners have any questions to ask the attorney? Commissioner Gamble.
So you were stating that the design of this house would potentially impact future acceptance into, I guess, impact area?
Right, the intact historic area.
Intact. So has the area made an application to be considered for an intact historical area in the past?
They have not, but the National Historic Preservation Act provides protection to historic properties, which are defined as properties or districts that are on or eligible for listing in the National Register. And so it already has the protection, just the eligibility provides the protection. But as far as I know, there has not been an application for just the intact historic area as its own district.
Do you have any additional questions, Commissioner? And follow up to that, I recall when we had our last hearing, there was actually a map or outline of the historic properties. Do you have that to share with the board?
Yes, so I can put it up. It's in the position paper, but I do have one here. I can pull that up. And you're talking about the map showing the intact historic area in relation to the rest of the district?
Yes, sir.
Okay. So, and there's actually, in the Historic Preservation Commission's position paper from like 2 days ago, there was a question raised about the actual boundary of the district, and I think we can probably stipulate on this, but this map right here is from the county GIS, and it is the same as what we presented, and I don't think what was in the position paper of the HPC is accurate. And that
Okay.
but so I would actually like to tender this map too, since there seems to be a question about it. And in fact, if the HPC's map were accurate, then under any standard, the decision would have been wrong, because the homes that they considered that were outside the intact historic area are in the part in the southwest that their map was showing was not in the district.
Yep. Okay.
So, for example, the Gann house was, and the entire subdivision with the modern homes was.
Mr. Schwartz, I was about to tell you before I turn on my microphone, I was about to tell you if you would please turn back into the microphone, it'd be helpful.
Well, my only point is that this is from the county GIS map, and I think, but getting back to your question, Commissioner Cupid, this map on the screen is, the yellow is the district, and the shaded area in gray is the intact historic area.
And your argument is to compare properties to the intact area or to the entire district?
Our argument is that when, so what the Historic Preservation Act requires is that when issuing a certificate of appropriateness, the Historic Preservation Commission has to make a determination as to whether there's going to be a substantial adverse effect on the district. And what the Historic Preservation Act says on how to make that determination is you consider the relationship of the proposed structures, architectural features and styles, and you compare that to the architectural features and styles of other structures within the immediate neighborhood. And so what we're saying is that, we say that the immediate neighborhood is the intact historic area. And the Superior Court agreed with us on that. And they said, not only do you have to look at that for your consideration, but you have to limit your review to the immediate neighborhood. You cannot look outside of it. And so here they were relying on modern homes that were outside of the intact historic area to show compatibility.
Are there any historic properties, well, let me make this observation instead of making it a question. From looking at this, it looks as if there are historic properties that are not in the intact area, but that are in the district.
That's true. I think there's at least two. There's the Gann House and maybe Ruff's Mill. Is that?
Yes, per your chart, I see that. And so I'm just trying to understand how we identify this intact area that excludes those historic properties. However, there's been a comparison of looking at the historic properties in the past, which have included those two properties, and now I'm hearing we should exclude those, which would lead to us excluding any other houses in between those two properties. But I recall a prior argument is that because those historic properties are in those more distant areas, that should facilitate looking at properties in between those two structures.
So the intact historic area was identified in the nominating report when the county was considering creating this district. And so they drew the proposed district outline in yellow, and they shaded in the intact area. That's where that area
Okay.
specifically came from.
Okay.
When we went to the Superior Court, we argued that the review for immediate neighborhood, that really it is the intact historic area. That's what
Okay.
the immediate neighborhood is.
Okay.
And the Superior Court agreed.
I hear you.
And, then said it was error to
Okay.
even consider homes outside of that.
Okay. Did your comparison include comparison to Ruff Home Place and to the Gann House?
In this application, no.
Okay. Okay, very good.
Okay.
Thank you.
Thank
And
you.
then, did you have a question to piggyback on that? Not to piggyback. Okay, I still have another question for you. The standard of review, I'm hearing multiple potential standards of review. There's the Historic Preservation Act, there's the revised county code or the prior code, and then there's also the Secretary of the Interior's assessment of historic property. And you're saying that two of the three should apply?
So what we're saying is our argument is primarily focused on the failure to follow the requirements in the Georgia Historic Preservation Act at OCGA 44-10-28B, which is the part that requires making the determination based on comparing the architectural style and features to other structures in the immediate neighborhood. So that's
Okay.
in the Georgia code.
Okay.
And we're saying that did not happen. So,
All
and that there's two issues relevant to that. One is just that they looked generally at homes outside the area. That they never distinguished between the intact historic area and the rest of the district, which was one of the errors that the Superior Court found. And then also just besides for limiting it to the intact historic area, also another error, it happens to overlap, but another error was basing compatibility on homes that have no architectural style or historic significance. So that's kind of two arguments right there. And then a third argument is this is under the county code and the county and the HPC bylaws, which is that they did not require the submittal criteria. That was one of the issues that the Superior Court ruled on. She said that is absolute. You have to have it. And then another argument that we've raised, but I don't think that the board needs to even address this in ruling necessarily, but we're essentially saying that because the revised code is saying to make its determination instead of on comparison to the immediate neighborhood, it's saying base it on the Secretary of Interior standards and guidelines and any other guidelines from the HPC. Here, there are no design guidelines. And so that just leaves the Secretary's standards and guidelines if you're going to ignore the Historic Preservation Act, which you can't. But if you did, what we're saying is it really doesn't leave anything left if as the standards say, they don't apply to new construction.
Okay,
Thank you.
Commissioner?
I just had a quick question. If you can just point out the subject property in relation to the map that was just on the screen?
Sure. So if you take a look at this map, and then I'm going to flip the page, and I'm going to be able to show a little better.
Thank you.
Okay, thank you. And actually,
Thank you. Are there any other
I'm sorry.
questions, Commissioner?
I took-
Commissioner, go ahead, sir.
I took the county GIS map off of the overhead, but I'd like to tender that as an exhibit also.
Thank
So
you, sir.
I'll pull it up when I get it.
We have another question for you.
Okay.
So if I understood you correctly, you said that the Georgia code requires you to review by the immediate area.
I'm sorry.
If I understand you correctly, you said that the Georgia code requires you to review for the immediate area for
Yes.
architectural. Does the Georgia code define what immediate area is?
It doesn't, but that's where the collateral estoppel res judicata come into play here, because on this specific site, it's already been determined by the court that it's the intact historic area.
But does the Georgia code define what an intact area is?
Well, no, because that term came from the specific nominating report for this district. They just happened to call it an intact historic area. That's not a term of art or a legal term. It just happened. It could have just been called the covered bridge neighborhood or something. It just happened to be the term that they used, and that the Superior Court found was the immediate neighborhood. Now, there are some codes do define how to identify the immediate area, and it's often referred to as it's like the homes on like a certain section of a block or a block, on both sides of a road between two streets. But there are some codes that do define it, which does help, because then at least there's not going to be an argument each time as to what they're supposed to be comparing it to. But here it's already been determined.
Any other questions?
Just as a follow-up, if the code does not determine what an intact area is, then how did you arrive at that decision of that particular area being intact versus the entire historic district?
Well, when we were in front of the Historic Preservation Commission on one of the earlier appeals, I asked our expert, Dr. Weitz, what would that mean? And he said, in this situation, it should be the intact historic area. And that's how we came up with it initially. was just trying to understand, because Dr. White's he's a planner and he works for the city, and just trying to understand how is this generally defined and like how would that apply here?
Okay. And did you mention that Dr. Weiss was your
Our expert on
expert,
yeah,
okay.
historic preservation, and that's whose affidavit we submitted this morning, and that's who provided Mr. Davidson several years ago the markups showing like how he could make this site like fit in better, because we've never said that a house can't be built here, and Dr. White's doesn't even say that any house would impair the eligibility. It's just as designed, this house would, and the district was already created before Mr. Davidson bought this, so he bought into this understanding that there were rules that apply, and the court addressed his concerns about hardship and said, well, there's no hardship because this is at the end of the opinion, because he can keep applying. He just has to submit an application that meets the standards, and that's not a hardship. It's not taking away his economic use of the property. He just has to, he just has to make it so it's compatible with the surrounding area, not matches it or mimics it, but compatible with it.
Right, okay. But Dr. Weiss's opinion was just solely his opinion. It wasn't based on code of any sort.
Correct.
Okay, all right.
But now that's the law in this case because of the Superior Court order. It's already been determined that is. And so, I mean, that's something that you can speak with counsel about the preclusive effect of that decision, but it's the law, that's how it, yeah. It's been determined for this case. Okay, thank you.
Any other questions? Okay, thank you.
I'm sorry, this is the map that I want to tender the district. And I'm tendering the county GIS map of the historic district.
Again, good afternoon, Commissioners. At first, I'd like to take notice of the Historic Preservation's position statement, Exhibits A through L, as entered into the record, in addition to a recording of the hearing from September 27th, 2021 of that commission hearing. At that commission hearing, the Historic Preservation Commission heard an application for this parcel for the fourth time. Applicant addressed the commission, appellants addressed the commission, and the decision to approve the application relying upon the Cobb County Code was approved by unanimous vote of 4-0. The COA was issued to allow construction of a new two-story single-family home based upon the submitted architectural plans. And I do want to point out that in your book that was provided, Exhibits A and B do have maps of the district. And I think on Exhibit A, it's the same map with the yellow markings that Appellant's Counsel said we did not include, but it's the same map. So it is in there, the entire district, with the shaded area of the intact historic district, historic area. At this time, we'll take a view of the district and the corridor. And I won't necessarily read each one, but
Mr. Rawling, can I stop the time and ask a question for clarification? To Mr. Johnson. I wanted to make sure because I didn't want to. So as we're viewing this, because there's been question about the immediate area and the intact area. The area that we were just viewing, is that the immediate area or the intact area?
For the pictures or in the map?
The pictures where you're viewing.
The pictures are primarily the intact area, but there may be a few of the district and the road corridor as a whole.
It's primarily the intact area, though.
Yes. Okay. The plans submitted with Davidson's application show that the proposed dwelling will be approximately 4,605 square feet of heated and cool space. And here, which is also included with the application and exhibits within the position paper, and I believe appellants included it as well, the front exterior and the rear exterior. The application describes the design of the proposed home as contextual, relying upon the context or setting to make sense, and that many of the design features are a direct reference to the district, such as natural stone, wood beams, timbers, and hardy plank sidings. Natural stone walls will be used to anchor and organize the floor plan in reference to the Concord Woolen Mill ruins, which was an inspiration for the parallel walls in the design. The design also incorporates heavy use of wood timbers in reference to the covered bridge. The steel sash windows will be used in reference to Ruff's Mill. The sloped gabled roof lines are designed to match the angle of the roof lines of the rock house, in addition to incorporating the shingled roofing. The plan shows a two-story home, one story from Concord Road and 2 stories from Covered Bridge Road in the rear. The bottom level is a basement, but due to the topography of the lot, is a full walkout basement not viewable from Concord Road. Appellants argue that the commission erred for several reasons when approving the application. First, the commission did consider the architectural style of the existing dwellings in the intact historic area and the district. Certificates of appropriateness are considered by the commission utilizing the United States Interior Standards for new construction on vacant lots pursuant to the Cobb County Code. The commission did not err because it relied upon staff analysis, which were compared a variety of dwellings in the intact area with special concentration on the rock house. And fourth, the COA submittal criteria was reviewed by the commission, was accurate and complete as determined by the historic preservation planner. Appellants' appeal primarily relies in large part on 2 words, immediate neighborhood, and this term was removed from the Cobb County Code by this board in February 2021, and it was removed because the judicial order from the Superior Court held it was undefined because it did not include a intact historic area. And then next, we actually have an attempt to show the intact historic area. The orange area is the intact area, which is the immediate neighborhood. And for 2 primary reasons, the intact historic area plus the district is the proper area to consider when reviewing the certificate of appropriateness for the new construction home, because there's a variety of historic dwellings further out from the intact area, and as previously acknowledged by the appellant's counsel. While the design of the proposed home is more contemporary, in a district with a long, significant, and many different building styles, it's easier to make an argument for this design. As the prior photos depict, there are contemporary homes already exist in the area. Even the historically designated dwellings have been modified and modernized. The staff report was reviewed, which analyzed the potential impact of the proposed dwellings as it relates to adjacent homes, specifically the rock house, which is the most adjacent and the most immediate dwelling to compare. The use of construction materials and retention of much of the tree canopy will mitigate any impact, according to the report. Appellants contend that the term immediate neighborhood is the only scope of review. However, the state of Georgia's model ordinance for historic preservation does not include the term. The model ordinance is directly derived from the Georgia Historic Preservation Act, which is now administered by the Georgia Department of Community Affairs. Upon review of the proposed amendments to the county code in 2021, DCA responded that it had no comments as to the proposed changes, and that is a positive response from administrative review. Cobb County Code Section 6682 and the model ordinance state that for new construction, the certificate shall be issued if it conforms in design, scale, building materials, setback, and site features, and to the Secretary of Interior standards. Even the section title refers to new construction. Cobb County Code Section 6683 provides that when considering applications for appropriateness within the historic district, any design guidelines or other criteria adopted by the commission for that district shall apply. But here, there are no design guidelines. The county relies upon the standards, the Secretary of Interior standards for guidance. Cobb County Code 6685, the commission found that Davidson's application would not have a substantial adverse impact on the aesthetic, historic, or architectural significance and value of historic property within the district. As code directs, the commission considered and applied standards 9 and 10 for Davidson's application. 9 states new additions, exterior alterations, and related new construction shall not destroy historic materials that characterize the property. The new work shall be differentiated from the old and shall be compatible with the massing, size, scale, and architectural features to protect historic integrity of the property and its environment. The standard provides 3 important review considerations: characteristics of the property, differentiation of new work from old, and compatibility with existing in terms of material, features, size, scale, and proportion and massing. There's no mention of design or style. Additionally, Standard 10 states that new additions and adjacent or related new construction shall be undertaken in such a manner if it is removed in the future, the essential form and integrity of the historic property and its environment would be unimpaired. The age and styles of the home within the district at the time of approval in 1986 allow for the proposed home in this district. As described at the hearing, the existing district is 93.04 acres, contains 42 structures. Of those structures, only 4 historic homes are in the district. As you saw in the previous pictures, homes located in the districts are varying architectural styles of contemporary to traditional. Again, it's a map of the district. The county and the area residents have attempted over the decades to have the district designated as a historic district. However, after site visits and consideration, the then administrator of the act, the Georgia Department of Natural Resources, determined that it was ineligible, for it lacked the lack of significant concentration of historic resources. The cumulative result of major construction projects of the district during the 90s have resulted in the area no longer being eligible. Appellants contend that the application package did not contact correct submittal criteria and should not have been reviewed by the commission. Appellants overlooked the first paragraph of the form that also states a clear descriptive submittal be received, and that is exactly what was received from Davidson. Further, it should be noted that this is one of the most detailed and complete application packages ever received during the tenure of Ms. Mandy Elliott as Historic Preservation Planner for Cobb County, even exceeding and surpassing the previous applications for this parcel. Moreover, this application directly addressed the Superior Court's order and explains in details how the proposed dwelling complements the intact historic area plus the natural topography of the district. Appellants allege that one of the submittal criteria listed in the submittal criteria form is incomplete. Here's a table of what they say was missing versus what Ms. Elliott explains in the right column. They're saying a floor plan showing setbacks was missing, but if you look at the submittal criteria, there's clearly maps and floor plans with setbacks showing Nickajack Creek in the application. Appellants further argue commission should have not reviewed this application due to the buffer for Nickajack Creek is not correctly shown. Rear setbacks are not necessarily relevant to the commission. Second, setbacks and buffers fall under the purview of the Cobb County development standards, and those development standards are enforced by site plan review when any disturbance is issued. This was expressly discussed during the hearing. Further, the rear portion of the parcel is intended to remain undisturbed as it slopes down to the top of the bank and then the 15-foot final drop to the creek below. Interestingly, the landscape plans for the remainder of the parcel were drawn by a former appellant and the adjacent neighbor. Davidson provided a detailed application package which contained more than sufficient and correct information for the commission to make a decision. Mandy Elliott's unable to participate today, and she provided an affidavit, which is attaches Exhibit L to the position statement. This affidavit explains her qualifications, her experience, and review of this application. The staff report recommended approval for numerous reasons. For Ms. Elliott affirms that primary deference was given to the rock house based upon review of the construction materials, style, retention of the tree canopy, and arrangement within the setbacks on the parcel in question. Further, Ms. Elliott noted that the design protects the visual aesthetics of both the intact historic area and the district. As stated in the code, the standard of review of the commission's decision is whether the commission abused its discretion in reaching a decision. Discretion is defined as the exercise of judgment based upon what is fair under the circumstances and what is guided by the rules and principles of law. When reviewing a decision applying the abuse of discretion standard, this Board of Commissioners must affirm the decision of the Historic Preservation Commission if there is some evidence in this record to support that decision. It's not whether this board would have made the same decision. Again, the approval of the certificate of appropriateness was proper as approved by the commission when it considered the application in accord with the Cobb County Code. The commission relied upon evidence presented, properly used its discretion to reach its decision regarding the proposed Davidson dwelling in relation to the existing homes, with special deference given to the rock house, which is the most adjacent and proximate dwelling. Once again, a picture of the proposed home. There was no abuse of discretion on behalf of the commission, and I ask that this Board of Commissioners uphold that decision to approve the certificate of appropriateness for the David residents, to affirm the decision and find there is no abuse of discretion. Thank you. Are there any questions?
Mr. Johnson, there may be some questions for you if you'd stay there, please.
Commissioners, do you have any questions?
Brian, if you can go back to the photos of the properties in the intact area, particularly the rock house. But let's just start from the beginning, and if you can, just point out for us which homes are in the intact area versus in the historic area.
I'll reference back to the exhibits in the position statement. If you look to Exhibit
Okay.
B, I believe.
Well, I actually wanted to see the photos.
I'm going to.
Okay.
I just want to, so you can reference before we look at the
Gotcha.
pictures
Okay.
in the PowerPoint.
Okay.
But you see the proposed structure. You have the rock house most adjacent and proximate. You have the covered bridge down the road a little ways. You have the miller's house, the grist mill. You have ruins. And I don't believe the rock house is depicted on that. Pull this back, go back to PowerPoint. So looking at this, the miller's house is in what would be described as the intact area.
Okay.
I do not believe this would be.
Which house is,
Unless-
which house is that, do you know?
I'm not sure unless Mr. Schwartz is aware which.
Well, that says 79 Concord Road, it's not in the intact
Yeah.
historic area.
100 Concord Road, which, I believe it's further past the bridge. The rock house.
The rock house is in the
It's right.
intact.
Yes, it's right next door. And that was the,
And what year was that built?
around 1900, unless there's, appellants would
Looks like
argue.
there's some-
I believe someone said 1890.
Was that the only one? Was that the last one?
That was
that
all
the
the
last
pictures
one?
of the houses. Yes, ma'am.
Okay. And just a follow-up question, because what's before us today, again, is to determine whether or not the board abused its discretion. And there were 3 points that were made earlier with respect to why the appellants believe that the abuse, that the power was abused. One is comparing the immediate neighborhood. And we heard from both sides, an argument on both sides as to why that tight area is considered intact versus the entire district. The submittal criteria also, you clarified that for me as well. But there was mention earlier with respect to the board relying on non-historic or intrusion homes. And perhaps this may be a question for Mr. Schwartz, but I'm just trying to figure out which of the homes that are on this list would be considered an intrusion home, or which home was compared by the HPC as an intrusion home.
I don't think I can answer that directly. I would defer to Mr. Schwartz based upon their contention that the district as a whole should not have been considered. The staff report did consider some homes as a district as a whole because that's what our county code relies upon, and that's what has been designated by this board as historic. The order that he references did come out of litigation and an appeal. It directed back to the Historic Preservation Commission, which the county then took that order as a role of its judicial review and made changes to the code so that based upon the order, our code would be legal with what the order said for us, for the county and the Historic Preservation Commission to consider. The appellants, in keeping with that, appellants are arguing about uniformity, and he's mentioning Historic Preservation Act. Those are questions of law which are above this board's and this consideration. But the fact that county code and other jurisdictions rely upon the model ordinance to draft their ordinances, which is a reflection of the Historic Preservation Act under Georgia Code, and we are in complete compliance with the model ordinance, that we, I would argue that there is no lack of any constitutionality. But again, I don't want to get too deep into those issues. Those are above this board's consideration and questions of law.
Okay. That's all I have.
Thank you. Any other questions? Yes, and I think that's where my questions hinge, on those questions of law versus what our specific role is as a board. So help me, Brian. I'm gleaning that based off of the judge's opinion, we took that opinion and then made changes to our code.
Correct.
And then went back through the process with respect to the update that we made to the code.
Correct.
I'm perceiving the argument of the attorney for the area is that the judge directed us to take a look at this again based off of her opinion and not necessarily change the code because we are unable to go back and change the code based off of that opinion. I think the word "we stopped" was used.
I believe that's what appellants are arguing. The attorney, Mr. Schwartz, is saying that the order would have been a direction to the Historic Preservation to go back and reconsider the application.
Yes, yes.
Under that. But it was the determination, if that's what the order was going to do and have the county change the code anyhow based upon a judicial review, that was the option that was taken by staff to change the code.
Okay.
Just for a point of clarification on the code, can you just walk us through what was changed?
There are a few items that were changed. Specifically, the term immediate neighborhood was removed. There were some areas about the what square footage and size taken into context of what can be reviewed. In the previous appeals for this parcel was the contention that the Historic Preservation Commission could not provide stipulations in an approval. Appellants had contended that the Historic Preservation Commission could only approve or reject a certificate of appropriateness application. And when they did so on one of the previous appeals, they added stipulations as to some of the design and and to the setting. And the Superior Court said no, that they could not add stipulations. And so that, based upon the order going back, language was added to the code to allow that authority for the historic preservation to allow for stipulations in their approval of certificates. There might have been something else, but I can't think off right now what that was.
I think the issue of the immediate neighborhood was also addressed in the code.
It was removed. The language, immediate neighborhood was removed from the code. And what I recall, based upon staff comments at the time from Mr. Jason Gaines and Ms. Mandy Elliott, was that they were relying upon the model ordinance as direction for code revisions, and the model ordinance did not include that term.
Thank you. Thanks.
And I would like to take this moment that Mandy couldn't be here, and her mother passed away last night.
so
She had been
sorry.
in hospice for a while.
I'm so sorry to hear
even as we consider this, just to think about her and her family, and a host of other families right now,
Yes.
as we deliberate this issue.
Thank you. Okay. I need to take a 5-minute recess. Sorry, thank you.
Thank you. As I introduced before, I'm Kevin Moore. I'm here and pleased to be here on behalf of Mr. Roland Davidson. I'm not going to repeat. What I'm going to try to do is fill in some blanks and provide some further explanation from Mr. Davidson's standpoint as it relates to this. There's been a lot of discussion, as there was in the prior appeal hearing that we had right here 4 years ago now, a lot of discussion about immediate neighborhood, intact historic area, how does all this work? So, and I think that those terms aren't interchangeable. They're two different things. The county did something in 2021 when it amended its own historic preservation ordinance and removed the phrase immediate neighborhood. You as a board and this county did something at that point in time. You changed your ordinance and it meant something. We have to have it has to mean something. One of the most basic principles of law is that when we look at ordinances, when we look at statutes, we have to give meaning to them and meaning to all parts of them. We have to give meaning to that. In the prior case, when this appeal was heard before you as a board, not this composition of the board, but the Board of Commissioners, the Board of Commissioners upheld the HPC's decision. But at that point in time, the county code actually stated immediate neighborhood in the standards for consideration. That's what went before the Superior Court. And the Superior Court made its ruling and overruled that and sent it back saying, but based on the county ordinance, based on the state law, HPC county, you need to review the application with that standard in mind. But the county changed the standard, which was an option. In fact, that's an option at any time for the board to adopt and amend its ordinances, and it can change the standard. But that's what this county did. It changed the standard and removed immediate neighborhood from the code at that point in time. After that, there was yet another submission by Mr. Davidson. There's been 4 in all, please keep in mind, 4 of these. 4 times they've been issued a certificate of appropriateness. This is now the second time that's reached this stage. After the removal of that phrase from the county code, certificate of appropriateness application was made. As you heard from Mr. Johnson, Ms. Elliott, the director of the commission, stated it is the single best application, most complete application that she's ever seen as part of her commission. That speaks a lot and speaks volumes from somebody like Ms. Elliott. But going back to the immediate neighborhood, intact historic area, and so forth, immediate neighborhood is a term, it's a phrase, it's not a defined phrase that's in state law. Now, the appellants rely heavily on that state statute, the Georgia Historic Preservation Statute, and say, well, that's the standard that applies, the immediate neighborhood. And further than that, even though it's not defined in state statute, we're going to go to the county code and talk about intact historic area. But we don't want to apply what's in the county code because that's not applicable, just the intact historic area. But funny thing, if you went to the county code right now and opened that thing up, you don't see the phrase intact historic area as it's related to the Covered Bridge Historic District. It's not in there because the county didn't adopt it. It was in a nominating report. That's where that map is that has the gray area that says intact historic area. It was in a report that the county took under consideration while it was considering, do we designate a Covered Bridge Historic District? Then the county's actual action, which is also in our position paper, when this county actually adopted the Covered Bridge Historic District, it adopted the district with the boundary. There's no reference to the intact historic area. It's not in there, doesn't exist. Now, it's a handy reference, okay? It was certainly part of the Superior Court hearing. And importantly, it was part of what the Historic Preservation Commission considered. You saw Ms. Elliott's testimony in regards to that. You saw what the commission did in issuing this certificate of appropriateness, and they certainly did specifically consider, call it the intact historic area, call it the immediate area, call it the area around the house, proposed house, whatever you want to call it. They specifically referenced that and said this is part of our decision is based on this particular area and the compatibility of what's being proposed from the single-family home design by Mr. Davidson is part of our consideration. They considered other things as well, but they considered that heavily in their deliberations. And that's all that's called for. They don't have to limit it just to this, quote, intact historic area. They don't have to limit it to that. They just have to make sure they consider it. The problem the first time was they there was no reference, and they didn't consider it as a matter of record. They just considered the whole district. But again, we can't give the intact historic area or the immediate neighborhood something different than we give the district. It has to be a part of all of it. It has to all be considered. Otherwise, you don't get to consider these other structures that are hugely important that aren't in the, quote, intact historic area. It just so happens this property is within that small gray shaded area. But there are, what is there, only 2 historic homes in the intact historic area? And many, many others that are not. The other historic structures are located outside. Surely we want to consider those. That's what makes up the Concord Bridge Historic District, is all of that taken together. And it's important that the HPC, that commission considered the immediate neighborhood. That's what the state law says to do. That's what they did. Very plainly, as part of that record. What does the state law tell us to do? It simply says that they are to consider elements as the architectural style, the relationship of those features to the exterior architectural style, and pertinent features of other structures in the immediate neighborhood. That's what the state law provides. That's what the Historic Preservation Commission did as part of their deliberation, and that's part of the record. The intact historic area, if we want to call it that, call it the immediate neighborhood, call it the surrounding area, what does it contain? It contains a variety of architectural styles, all of which are considered as part of this decision for issuing the certificate, all of which are considered and incorporated very well, mind you, into the design that's proposed by Mr. Davidson for his personal home. And all of those were considered and are appropriate here. Keeping in mind that, and you heard this reference before, keeping in mind that when you're dealing with a new construction, what is absolutely considered the no-no is if I'm going to build a new construction in a historic district, I don't build a pseudo-historic home. That's the term you see. It's referenced in the Department of Interior. It's specifically referenced by Ms. Elliott when she spoke to Mr. Davidson as part of the affidavit. Don't design pseudo-historic homes. Those are not compatible. We don't want pseudo-historic. You have to have your own design, not something that's pseudo-historic. That's really not allowed. So when we look at this, and if you are looking at the design at all, don't think it needs to look like the Rock House, or it needs to look like the Miller's House, or it needs to look like some other historic. What it needs to do is be compatible and incorporate that. And what the commission is called upon to do is consider those factors and either issue the certificate or choose not to, and base that decision upon appropriate standards, which they did here. It must be distinguishable and compatible, and that's what they did here. Going to the submittal criteria, I want to be real clear. Again, the staff found that the application was the best one they'd ever seen and that it met all submittal criteria set forth in your ordinance. What has been pointed out by the appellants is that they claim that a setback was not shown appropriately on the site plan, what we usually would call it. And they call out a setback from Nickajack Creek. Where the appellants get it wrong is the difference between a buffer from a stream like Nickajack and a setback, which is from the property line. Those are two different things. The setback is shown. Whether the buffer is shown or not is irrelevant because what's required for the submittal is the setback, not the buffers. So that's why their argument regarding the submittal criteria is simply not based on the code and on the facts as we know them, because there's a difference between a buffer and a setback. Those are two different things, and I want to be sure that was explained very clearly. I also want to be sure that we completely do away with this notion that somehow the building of this house will have any impact on the eligibility of this particular historic district on the National Register of Historic Places. Let's put that to bed, because we have the letter dated January 6, 2012 from the Historic Preservation Division of Georgia, wherein they respond to Ms. Elliott about the district's eligibility and whether it will be considered on the National Register, in which they say it's not eligible. Back in 2012, 10 years ago, they said this property, this district is not eligible for listing in the National Register as a historic district. I'm reading straight from it. Due to, at that point in time even, a loss of integrity and lack of significant concentration of historic resources. The cumulative result of major construction projects through the district during the late 90s, through the present have resulted in the area no longer being eligible for listing in the National Register as a historic district. That was of 2012. Nothing's changed in terms of those factors. So no matter what happens going forward, those factors will always be present that were present in 2012. Those major construction projects, primarily being the East-West Connector and other types of major projects, which are there and will continue to be there. So let's not confuse the issue, please, about the eligibility of this district for the National Register. That case has been decided, determined, and is closed. And this letter, again, is part of the record and part of our submission as well. Lastly, and I have to do this because this is an appeal hearing, and you're acting in that capacity as Mr. Rowland advised you, and that is I need to make sure these are also items that are clearly expressed in our position paper, and these are simply matters, legal matters that I just am required to raise before you, both in the position paper and as part of this. And that is from Mr. Davidson's perspective. And that is, should this board determine that the HPC acted improperly and reject this issuance of the certificate of appropriateness, what are the claims from Mr. Davidson's standpoint? Primarily, number one, we would consider that an unconstitutional regulatory taking of his property. Why? We've been here since 2017 dealing with these regulations on the historic district for Covered Bridge area, with him trying to just simply build a home on one home on 1.5 acres. He was well aware of the district. That's why he bought there, actually, because he is so well qualified to do this. They sought that, but yet, because of the ordinances, because of this district being applied to this house, because of what's happened over the course of these now 4 going on 5 years now, the regulations in place have made it so he can't use his property for exactly what it's entitled for. That is just to simply build a home. And if he can't use his property because somehow these regulations cannot be applied to allow that for him to do that, that's a complete regulatory taking of Mr. Davidson's property. Number one. Number two, you heard it. This is about the process from the appellants. They say that under the county's code, there's no standards to review for new construction. That's their position. Now, if that's correct and if that's the basis upon which this commission rejects the Historic Preservation Commission's decision, that there's no standards under the ordinance to review, then the ordinance itself is unconstitutional on its face. It has to have standards. If there are no standards, it's unconstitutional on its face. What's the remedy for that for Mr. Davidson? Under the law, the remedy is the ordinance no longer applies to him and his property. That's the remedy if there are no standards, as stated by the appellants. And we would urge that again, that for this application to again be rejected is simply reflecting that there are no standards. And when there are no standards, it's an unconstitutional ordinance on its face and should not apply to Mr. Davidson's property. And that likewise applies to the entire Covered Bridge Historic District Ordinance. If a single-family home on 1.5 acres through 4 submittals and 4 approvals by the HPC can still not be allowed to build a home on this property, then the entire Covered Bridge Historic District Ordinance must be unconstitutional on its face because it lacks the standards necessary for an applicant to get approval. And the whole district should be thrown out as a remedy. Certainly, if we end up in that place in court, that is a remedy that Mr. Davidson will seek from the court, to have the entire district thrown out. Lastly, and I think this continues, should we continue to be in this position of appealing and going forward, it will certainly be Mr. Davidson's goal and exhaust every effort to petition this board to take upon itself the ability to throw out the Covered Bridge Historic District by ordinance and simply identify these 6 structures as individually listed historic sites, and let's do away with the district if it's not working. That'll be Mr. Davidson's goal, so we don't have to do this again. It's imperative that I bring those to your attention because of the nature of this setting, this appeal hearing. But again, we don't believe those remedies are necessary here. Your Historic Preservation Commission has reviewed this 4 times. The design, in fact, has changed. If you'll, for those that were here on the prior hearing, you'll recall the huge, long discussion about how to measure square feet. We went on and on about that. Well, that's no longer a part today, but regardless, Mr. Davidson changed the design of the home by making it smaller. He made other changes as well. He has met with the neighbors. He has done all of these things in an attempt simply to build his home. The HPC considered all of the appropriate factors. They considered the immediate neighborhood. They considered this intact historic area, whatever that is, shown on a map in a report that's never been adopted by the county. They considered it, and they considered the district, all of which are appropriate, all of which are legally based, and all of which inescapably conclude that the certificate of appropriateness was properly issued by the Historic Preservation Commission based on the law and the evidence. And primarily, what was the HPC's decision? It was sound, reasonable, and legal decision-making without question. And that's what we're going to ask that you find. I'm also going to introduce Mr. Davidson to present and simply speak to you about a couple of things from his perspective to, again, like I said, bring a personal element to this, because I think it's important for his voice to be heard as well. But it won't be long. We certainly won't exceed our time. Thank you.
Well, appreciate the time here from the commission. We appreciate that. I'm going to keep this short because we've covered a lot of facts so far, but I've lived in Cobb County since 1981, taxpayer. I'm a licensed architect in the state of Georgia. When I bought this property in 2005, I met with Mandy, and we started to go through what the requirements of the house design would be. And through the standards of the Department of Interior, I was told no pseudo-historic structures would be allowed, and we've covered that point. So I thought as an architect, I would like to pick up on different design elements within this area. And I've lived in Smyrna since '81 and have driven through this area all those years. I love this area, the historic bridge, the efforts that were put in to save the covered bridge when the east-west connector, I mean, it's all fantastic. And as we started to go through the design, I went and had a survey done. So a lot of home builders would just go in there and tear down all the trees, put 3 townhouses in there, or 6 townhouses, or however many they can cram in there. This is not what I'm after. I'm after for a secluded home in a beautiful area. I had every specimen tree surveyed and located on my plan. The design of the house works around those trees, so they'll be saved. I photographed the area so that we could show not only the Historic Preservation Board, but the neighbors that from a lot of different angles, you really won't see the house because it's so wooded and natural. And I want to keep that. That's my goal as the architect and homeowner, is to keep that nice wooded area and having the creek and everything there to make it a natural thing. So through the design process, I've met with the neighbors who are on the appeal, and we've talked through a lot of issues together, and I've made changes to the design in an attempt to meet in the middle on some of the things that were requested. We removed a garage, so it's a smaller footprint for the garage. I moved the house further away from the rock house and committed to do landscaping so that we would screen the garage from their view from their home. And trying to do these kind of things to help make sure that we're having as little impact on the neighborhood as possible. So if you have any questions, I think that's everything. I will say during our neighborhood meetings, we worked through some issues and got some comments that were like, well, we don't want you to build anything. I'm like, but I own the property. Well, go somewhere else, buy property somewhere else. I was like, I have a huge investment in this property. I bought it, unfortunately, at the peak of the market. And I have a lot of economic things tied up in this effort. So, but anyway, if there's any questions, I'd be glad to answer.
Thank you. You have 24 seconds left. Do you wish to use it? Okay.
Okay, good.
Very
No,
good.
So
Commissioner,
simply, we'll make ourselves available for any questions. Thank you, Commissioners.
thank you. Are there any
And Madam
questions
Chair.
from commissioners? Thank you.
If I may. The hearing officer, I just want to be clear, because the semantics are very important in this situation. You said you've been here 4 different times. As I understand the record, Mr. Moore, and correct me if I'm wrong, this application on this instance was submitted on August 12th, 2021, and that's this application is not, that application has not been here 4 times. That's what we're dealing with today, correct?
That's correct.
Okay.
That's correct. No, this specific application and certificate is the first appearance before this board.
Okay.
Thank you.
Thank you. Bill, I understand there was some additional.
Yes, there's a summation period that each of the participants today are able to provide. Typically, in a usual hearing, the person who has to carry the weight can either waive or go first, or either waive to go at the end. That would be Mr. Schwartz.
Thank you. So I'll go at the end, but I've still got 5 minutes left, so can I just put that together so it's not disjointed?
Yes, you do. I'm sorry, yes, you do have the 5 minutes, yes.
Okay, can I put that together and just give you 8 at the end?
No, we need to go ahead and do the 5 minutes, and then, or if you want to make it all 8, we'll permit you to do that. Then the other 2 participants will be able to do their 3-minute summations.
Okay, and on my position paper, there was 10 exhibits. Do I need to tender those, or that's already part of the record?
That's part of the record, but we can go through that process at the end of that, yes.
Okay. I'm going to try and go through this pretty quickly, but just addressing some of the issues that were just raised. First off, on the comment about that they didn't identify the correct buffer, but that's different than a setback. A buffer is a setback, and you can see that in the code section at 50-130, which refers to stormwater design plans, and it refers to buffers and other setbacks. And they had the wrong setback on Nickajack Creek, and the court, in its order, specifically addresses, it says, clearly the submittal criteria document represents the requirements of the Historic Preservation Commission. And that was one of the reasons that the court reversed, was that they didn't include it. And here, yes, they included it, but it was wrong. We brought it to the attention. They could have gone back and fixed it, but they just decided to say, well, that's not a setback. In response to your question, Commissioner Gambrell, about whether a photo was showing the intact historic area or the immediate neighborhood, here they're the same, and that's at the court's order on page 15. It says the record reflects that Davidson's property is clearly situated within the confines of the intact historic area, and such should be considered as the immediate neighborhood. So the court found here the intact historic area is the immediate neighborhood. So I just don't want any confusion about that. And there was a comment by the applicant's counsel that about there's no requirement to limit the assessment to the intact historic area, but here that is not correct, because the Superior Court specifically said the court finds the Historic Preservation Commission erred as a matter of law by considering the proposed structure's compatibility within the compatibility with homes within the historic district, but not necessarily within the immediate neighborhood. So it's not just that they have to look at the immediate neighborhood, it's that they have to limit it to the immediate neighborhood. And Now, yes, it's true that term is not in the county code, but the only way that it's not required is if the the Georgia Historic Preservation Act doesn't apply. And for the reasons that we explained in our position paper, under Georgia's uniformity clause, it does apply. It has to apply. And I respectfully disagree with Mr. Moore on his claim that the questions of law are above the board. Now, the board may not be able to rule on constitutional issues, but certainly can, part of deciding whether something is an abuse of discretion is either that there's no evidence to support the decision or there's a clear error of law. And here we're showing that there is several clear errors of law. The part about the eligibility in the Historic Preservation Division's letter saying that there's no longer eligible for listing, that's referring to the entire district and not the intact historic area. That is still eligible, and the only evidence in the record here specifically says that it is eligible and that the house as designed would impair its eligibility, and that's Dr. White's memos that were submitted to the HPC and also his affidavit. And also in his affidavit at paragraph 2, he's referring to that the Historic Preservation Commission relied on intrusions. That's the like the newer homes that have no architectural style. Those pictures are at the application at page 12 and 13 because there was a question about how that was determined. But essentially, that's defined by code, and then just so. Let's see. And then the HPC's lawyer noted that in the standards 9 and 10, which are the Secretary of Interior standards that were applied here, that there's no, he said, quote, no mention of design or style. Well, that's exactly why this shouldn't apply here. So design is raised in the Secretary's standards at standard 6, but that's talking about if you are trying to repair an existing structure that, if possible, repair it, but if you have to replace it, then you're supposed to have compatible design, but it doesn't apply here. This is just our point. Well, my time is up, but I will speak with you in a few minutes. Thank you.
Mr. Schwartz, I assume you said you prefer to go reserve your time for the end?
Yes, please.
Okay.
Thank you.
With that, Mr. Johnson, you speak first, then Mr. Moore, and then the last 3 minutes of Mr. Schwartz.
As a reminder, the standard of review to be applied today is whether the Historic Preservation Commission abused its discretion when it approved this certificate of appropriateness, 21-05. The primary consideration is whether there was some evidence before the commission to support its decision. The appellants would have you believe that the dwellings in the attacked historic area were not considered by the commission when making its decision. They were fully considered based upon the staff report and the discussions of the commission on September 27th. Appellants also allege other dwellings and structures within the district cannot be considered when reviewing the applications, which is generally an attack on the district itself with all its variety of homes, over which only 4 are historically designated. But again, special deference was given to the Rock House, which is the most proximate and adjacent dwelling. Appellants contend that the commission erred when utilizing the Secretary of Interior standards for rehabilitation, but also consider that many local governments in the state of Georgia use those same standards, including City of Vienna, Sonoya, Troup County. And what makes those communities distinct is that they also have qualified local government status from the Department of Community Affairs for historic preservation. And what that means is they excel at historic preservation, and Cobb County is included in that. It's because we're applying the standards, we're adhering to the model ordinance. There is nothing vague about our code. There was nothing improper about the consideration from the staff report and the analysis that the commission considered. The application package was complete and contained all the information necessary for the Historic Preservation Commission to render its decision. All the floors and setbacks were available. There was sufficient evidence before the Historic Preservation Commission to support its decision. The commission considered all the evidence and testimony before it and properly approved Mr. Davidson's application. For today, I ask you to uphold the decision of the Historic Preservation Commission by finding there is no abuse of discretion in its decision. Thank you.
Thank you.
Thank you again for your consideration and what will be future deliberation on this matter. I want to just clarify so that you're crystal clear on our position as to the specific issue of the impact of the Superior Court order that happened in the prior case when the Board of Commissioners upheld the Historic Preservation Commission's decision at that time to issue a certificate of appropriateness under a different ordinance with different appellants. And that Superior Court issued an order giving guidance as to how to, giving guidance to the Historic Preservation Commission and county on what they should do given the ordinance at that time. This was a new application with a new ordinance, and the Superior Court's guidance should not direct what this commission decides in this matter, nor did it need to direct what the HPC did in its consideration. The HPC considered what was before it, a nearly flawless application, a standard in the county code that said to look at the district, a standard in the county code that said to look at the Department of Interior standards, as well as the fact that you have standards established by the Georgia Historic Preservation Act. That's what the HPC considered, and they considered all of that and appropriately and reached a decision to issue the certificate, and we respectfully request that you uphold that decision. Thank you.
Thank you.
One correction from what the applicant stated earlier is that he claimed that the problem was that the first time the application didn't consider the intact historic area, not that it considered the intact historic area and other homes. But that's not true. Last time they considered both, but the quote I was just reading you from the Superior Court's order at page 15 said it was error to base compatibility on other homes. And here, not only did they ignore the court's order, which the applicant refers to as guidance, but it's the law, and it's binding here. And not only did they look at homes outside the intact historic area, the immediate neighborhood, but they relied on the non-historic homes, the intrusions, to show compatibility. And even if there wasn't any issue about like which area to consider, it would be wrong to rely on compatibility with homes that have no historic value. It's completely against the whole reason to have a historic preservation ordinance. And of course, the applicant is relying heavily on the code and its revision, but the Georgia Historic Preservation Act still applies. That's Georgia Constitution, Article 3, Section 6, Paragraph 4 is the uniformity clause. And the Georgia Supreme Court has specified that a local ordinance cannot conflict with general laws passed by the General Assembly. And here, the code, to the extent that it's interpreted as not requiring the determination of a certificate of appropriateness on compatibility of styles within the immediate neighborhood, if that's how this is being interpreted, it's a violation of the Georgia Constitution. It's not in compliance with the General Assembly's law, and it also is it's directly against the instructions that the court issued here. Now, at the end of the opinion, the Superior Court at pages 17 and 18 provided instructions, and it reversed and remanded back to the HPC for review in conformance with the Superior Court order and the Georgia Historic Preservation Act. And that was completely ignored. Lastly, I would just ask you to look at the markups that were attached to Dr. White's affidavit and compare those to the application, the plans in the application, and you'll see almost nothing has changed. Okay, so this was provided years ago, 5 pages of markups of what should be done to make this better.
Mr.
and
Schwartz,
it's still the same.
sorry, time's up.
Okay, thank you.
So, Commissioners, we've heard an extensive amount of information regarding this. Considering that we are short 2 of our commissioners, I would ask that we do take the opportunity to consider what we've heard here today and have the ability for the other 2 commissioners to review the video and for us to come back and make a decision.
Yes, Chairwoman, and you're under our procedures and rules, you are able to take the case under advisement. As the Chairwoman often says, this material is dense.
Can you say that again?
As the Chairwoman often says, this material is dense. There is a lot of it. It'd be wise for you to do it. And also, I think it would also demonstrate to all the parties here to allow all the members of the board to be able to participate and show the seriousness of which you take this particular calling on sitting on this board. This would give you the opportunity to be able to do that. With that being said, I would suggest that in our rules would ask for this, that we set it back for a specific date. Our next zoning hearings is June 21st. I would ask that we just set that in the afternoon of June 21st, and we'll be able to get to it as soon as we can. That way we can advertise it. These hearings have to be advertised, and we have to go through that process, a separate process for that.
Okay.
If that works at 1:30. I would also suggest, and the rulings also provide for this, that the board request of all the parties to submit a draft order or draft findings of facts related to this, and then so that way you can have that at your consideration when this matter comes back up on June 21st.
Okay.
And I'll after the motion is made and carried forward, I want to reiterate the rules regarding the suspension period, if you don't mind.
Okay, and just for clarification on a few things you just stated, June 21st, we do have a hearing. I can set it for 1:30. However, similar to when we do have exec, if zoning were to run longer, at least we put the time there and we can come back and hear it after 1:30 should zoning coincide with that same time.
I mean, we could set it earlier. It would just be when the parties would have to show up and then wait at that point in time.
My only concern is I just don't know what the agenda may look like for that
Right.
day. And we'd have other parties also coming in for
Right.
zoning.
We could set it later in the day if you want to. I mean, I agree. In the morning, it probably wouldn't be good, but 1:30 or 2:30 would probably be
2:30.
preferable than just.
2:30, would you like the same time? Okay, so we can encourage that, we can encourage parties to take to do what they can to get their cases on consent. However, if the parties are flexible enough, we can advise them during that day of how things are running to see if we need
Sure.
to come at a later
Sure,
time.
we'll
I
be
have
able
a
to
feeling that-
talk to Mr. Schwartz and let him know if the zoning's running later, it might be a little bit later. We just can't start it before the 1:30, so.
Yes, okay.
And this way, to give the opportunity as well for the board to have lunch, which I know you guys
That's always a
oftentimes
good
press.
thing.
You
Yeah.
oftentimes press through, and it'd be preferable if you give an opportunity to do that.
Okay. And then I understand that you would desire for me to include in the motion for the parties to provide a draft order,
Or proposed decisions regarding.
proposed decision,
Yeah.
or you said, or finding of fact.
Or findings of
Is that
fact.
considered the same
I
document?
was
or
going
is
into
this two
court mode, I'm
separate?
sorry. That's
Okay.
something that we regularly do in court. You don't necessarily have to do that in this instance. And it could be, each party could draft it to the extent that they want to. which would go over why there was an abuse of discretion, why there wasn't an abuse of discretion, or it could be as simple as there is an abuse of discretion or not. We leave that to the discretion of either party to draft those as they would wish, but it would be for the board to be able to then consider at the next hearing.
So I will refer to that as a draft decision in the motion?
Yes, ma'am.
Okay. Commissioner Gaucher.
Should there be a time frame attached to when that should be submitted to the board for review?
I have a suggestion. I'm looking at my calendar. In order for the board to be able to consider it by then, also recognizing Memorial Day, if we ask for no later than June 8th, which would be 2 weeks from today, would that be agreeable to the parties by June 8th? Okay, that would be a date that we could shoot for then, for when those would have to be in.
Okay, are there any other clarifying questions or information in the motion? Bill, I'm going to refer to Bill. I see Kevin going up there, but this is a conversation between the board and you as the attorney.
Conversation
I don't
between
know.
us, and yeah, I don't have any questions, no.
Okay.
But I'm curious what Mr. Moore wants to say.
I don't know if it's appropriate. I don't know if it's appropriate to allow him to speak.
I know he just
Other
consulted
party
with
to
Mr.
speak.
Schwartz,
So
so-
you're okay?
Yes.
You're okay? Okay.
Thank you for that. This is more towards Mr. Rowland as the hearing officer. And for the record, just want to confirm that for each of the parties, that the exhibits that were submitted as part of each party's position papers are considered admitted into the record for this proceeding. It's just a cleanup for the record.
That's true, Mr. Moore, and I asked you if I forgot to come back and do that, so I appreciate you following my instructions at least. So all of the position papers are submitted as part of the record. There was an additional submission by Mr. Schwartz today, and each one of the commissioners have received these via email. There's a lot of exhibits attached to them. I think there were some that were handed out in person too, but the clerk's office has each of those. Okay, thank you, Mr. Moore. And they were referenced all throughout, an affidavit from Ms. Elliott, an affidavit from Mr. Wyatt, the expert. There were various pieces to that, but they are part of the record. Thank you.
Okay. Any other consideration? Okay, with that, I make a motion for this board to take what was shared in this hearing today under advisement and to come back and make a decision on this matter on June 21st at 1:30 p.m. I also ask, we include in this motion that we have a draft decision provided by all of the parties, provided no later than June 8th. And just for clarification, Bill, do I need to include in the motion the position papers and exhibits to be entered into the record, or is that just a note to the clerk?
That's
Okay.
She has that.
Very good. So again, just to restate that motion, my motion again is that the board take this hearing under advisement and come back on June 21st to make a decision on this matter, and that the parties provide a draft decision to the county attorney's office no later than June 8th. That concludes my motion.
Second?
Is there any further discussion, clarification? All right, we'll call the question. The motion carries 3-0 with Commissioners Burrow and Richardson absent today.
And to that point, Chairwoman, with your permission, I will contact both Commissioner Burrow and Commissioner Richardson, let them know the hearing is available as well as the materials are, for them to be able to review it and be prepared to vote and consider the case in open discussion on June 21st.
Okay, thank you. I
Okay.
appreciate that.
And one other, I just want to, we covered this at the beginning, if you will, council shall not discuss the case particulars with commissioners, members, or during the advisement period. No emails or public statements on this issue by any of the parties should be occurred after this date or should be considered by the board. The record is closed at this point in time. And with that, then we will pick this matter back up then on June 21st at 1:30. Thank you.
Just for a piece of
Yes,
clarifying
ma'am.
information, what if other members of the public beyond the attorneys were to contact commissioners?
I would contend that this is your deliberation period, and you should not look at anything else beyond the record at this point in time.
Thank you.
The parties are also the public. I appreciate that.
Thank
that
you.
question, yes.
Okay. All right, with that, this meeting is adjourned.